Good morning. Committee will come to order. I want to thank everyone for joining us this morning, and I especially want to thank the witnesses for being here today. I also wanted to take an opportunity to thank my ranking member, Representative Stauber. Glad to be getting to know you and look forward to working together to create bipartisan solutions to help small businesses all across the country, from Belfast, Maine, and hopefully I get this right, to Brainerd, Minnesota.
Brainerd, you did.
All right, there we go. America's small businesses are economic engines that drive growth and jobs in the U.S. economy. The nearly 30 million small firms in the U.S. represent 99.7% of all employers and generate 2/3 of all net new jobs. Back home in the state of Maine, where I come from, this is very much the case. But what's very interesting is how many of our small businesses are truly very small. We're talking 10 employees or less, make up the great majority. And firms like this play such a crucial role in our economy, and it's critical that Congress enact policies that promote small business entrepreneurship, job creation, and also provide opportunities for growth. In fact, Congress has created tax preferences and loan programs to help small businesses thrive. And as one of the largest purchasers of goods and services in the world, the federal government is in a unique position to support small businesses by providing contracting opportunities to help small businesses succeed. When we establish policies aimed at helping small businesses, one of the decisions that Congress has to make is how to define a small business. I think very much the subject of this hearing today, as you all know. How we define that business will determine who is eligible for contracting opportunities and other incentives designed to help small businesses compete. Getting that target right is important, as it can be too narrow, pushing a firm outside the size standard, or it can be too broad, allowing a large firm to compete in these programs and overpower the small business. The end result is the same: small firms deprived of federal contracting opportunities. Last year, this committee and Congress as a whole addressed this very issue by passing the Small Business Runway Extension Act, which requires SBA to use the gross receipts of a small business over 5 years as opposed to 3 years when considering granting federal contracts. This change was designed to assist small businesses successfully bridge the gap between competing in the small business space and the open marketplace against larger companies. The Small Business Runway Extension Act is a move in the right direction to ensure that small businesses can mature, become prosperous, and create additional jobs that spur economic growth without having 1 or 2 particularly good years or contracts bump that firm out of the small business category because it's ready to compete, before it's ready to compete with larger firms. Unfortunately, since the Runway Extension Act became law last year, its interpretation and implementation has been contested. Shortly after the bill was passed, questions arose as to whether the bill was to take immediate effect. Businesses benefiting from the 5-year change hoped, and I believe anticipated, that the change would take effect immediately, so they may continue to certify as a small business in 2019. Surprisingly, the SBA has suggested that the Runway Extension Act applies to every other agency adopting its own size standard, but not to the SBA itself. While the merit of that argument is debated by legal experts, the SBA is working on regulations to implement the law, and we're doing our own analysis by holding today's hearing. It's my intent that this hearing ensure that congressional intent is not thwarted and small businesses have the federal contracting opportunities that Congress decided and determined last year that they deserve. I look forward to hearing from our witnesses and exploring the controversies surrounding the implementation of the Act, discussing potential solutions to mitigate these challenges, and examine additional steps, if any, that may be necessary to ensure that this committee and Congress's intent is fully implemented in a timely manner. I thank all the witnesses for their attendance and insights into this important topic. I'd now like to yield to the ranking member, Mr. Stauber, for an opening statement.
Thank you, Mr. Chair, and I too look forward to working with you, and I appreciate this opportunity. You know, the Small Business Runway Extension Act, led by the former chairman of this subcommittee, was intended to be uncomplicated and straightforward. In fact, it changes only one word in the Small Business Act. Unfortunately, as simple as it was, the actual implementation of the law has been equally difficult. The purpose of the Runway Act was to allow graduating small businesses more time to build their competitive edge when competing against titans of industry in the open market. Recognizing the significance of this bill for small businesses, the Runway Act easily passed through both House and Senate, becoming law on December 17th of 2018. Quickly following the law's passage, the Small Business Association put the brakes on its implementation. The SBA sent an information notice to all federal agencies, halting the switch to the 5-year rule as mandated by the Runway Act. The SBA decided they would keep in place the previous 3-year calculation currently in regulation until the agency could undertake an assessment of the law through the rulemaking process. Unfortunately, for small businesses fluctuating between small and, quote, other than small, this conflict in the law versus regulation imposes significant real-world challenges in the form of potential size protests and uncertainty facing small businesses and their recertifications. Advocates for the immediate implementation of the Runway Act criticize the SBA's reasoning on what they view as a straightforward and helpful piece of legislation. However, businesses facing declining revenues applaud the SBA's cautious and transparent approach. Who is or isn't considered small is up for debate, and understanding how to best achieve clarity in the law may help alleviate this uncertainty. Regardless of who prevails in the legal arguments surrounding this debate, it is important that this committee take a practical, policy-oriented approach to this issue and identify how best to respond to the concerns of our small businesses. At the end of the day, our primary responsibility is to small businesses, and we must take the greatest care to uphold and protect their ability to compete and succeed. I hope through our testimony and our witnesses today that we can come to a greater understanding of the problem and discover ways to quickly resolve the issue in a manner that will provide clarity and consistency for small businesses. Thank you, Mr. Chair, and I yield back.
Thank you, Mr. Stauber. The gentleman yields back. And if committee members have an opening statement prepared, we would ask that they be submitted for the record. Take just a few minutes to explain the timing rules. Each witness will get 5 minutes to testify, and each member gets 5 minutes for questioning. There's a lighting system to assist you. I don't know if you've done this before, so I will go ahead and lay it out for you. The green light will be on when you begin. The yellow light will come on when you have 1 minute remaining. The red light will come on when you're out of time, and we ask that you stay within that time frame to the best of your ability. It goes by quick. I would now like to introduce our witnesses. Our first witness is Mr. David S. Black. David Black is a partner with the law firm Holland & Knight LLP in Tysons, Virginia, and co-chair of Holland & Knight's National Government Contracts Group. Mr. Black's practice involves serving as a trusted advisor, problem solver, and advocate for federal contractors, awardees, and subcontractors in every stage of growth. He provides legal advice and representation to help his clients secure opportunities, enhance performance, mitigate risk, and respond to threats. Mr. Black serves contractors and awardees in a broad array of industries with an emphasis on innovative technology, cutting-edge products, professional services, healthcare, and research and development. Welcome, Mr. Black. Our second witness is Ms. Megan C. Connor. Megan Connor is a partner with a law firm. I'm going to get this wrong. Perhaps you want to just go ahead and tell us what it is.
Polaro Mazza.
Polaro Mazza, PLLC in Washington, D.C. In that role, she counsels companies on a variety of government contracting and business matters. For small businesses in particular, she assists contractors with regulatory compliance, like affiliation issues, limitations on subcontracting, and how to maintain size and status. Ms. Connor also represents contractors in state and federal court concerning government contracts, business and employment matters. Ms. Connor received her Bachelor of Science degree, magna cum laude, from Boston University, and received her law degree, magna cum laude, from the University of Miami School of Law. Welcome, Ms. Connor. Our third witness today is Mr. Brian Morales. Brian began his career in the electrical industry at the age of 21 after finishing his education at San Diego Christian College. After obtaining his contracting license in 2008, Brian began working as a regional manager for an energy efficiency company based out of Connecticut and has managed large public projects in Alaska, Hawaii, Washington, Arizona, California, and Colorado. Today, Brian is a proud owner of ProCal Lighting, a minority-owned small business with a focus on providing equal opportunity to all genders, races, and education levels. Because of this approach, ProCal Lighting employs amazing individuals who represent the best California has to offer. Welcome, Mr. Morales. Thank you. I would now like to yield to our ranking member to introduce our final witness.
Thank you, Mr. Chair. Thank you, Mr. Chair. And our final witness today is Ms. Erin Allen. Ms. Allen is the president of Contemporaries Incorporated, a small business owner operating locally in Silver Spring, Maryland, and is testifying today in her capacity as vice chair of the Small Business Committee of the Montgomery County Chamber of Commerce. In her role as president of Contemporaries Incorporated, Ms. Allen provides extraordinary staffing services to clients in the D.C. metropolitan area, receiving outstanding recognition from satisfied government clients such as the National Institutes of Health. In her role as part of the executive committee of the Montgomery County Chamber of Commerce Board of Directors, she has been instrumental in identifying legislative and regulatory issues impacting small businesses and advocating for policies that benefit the small business community. Welcome, Ms. Allen.
All right, thank you very much. Mr. Black, you're recognized for 5 minutes.
Good morning. First, I want to say thank you, Chairman Golden. Thank you, Ranking Member Stauber, for the invitation. It's an honor and privilege to be here today to try to assist the subcommittee look at the implementation of the Runway Extension Act. Points I would like to make today are, first, Congress did a really good thing back in December. The current status is that it changed the 5-year standard. That's a law that went into effect. I have a little bit more on that in a moment. And small businesses have been relying on that change in the law. For the past 3 months, small businesses that would be large under the 3-year standard but are small under the 5-year standard have been submitting proposals for set-aside contracts. And they put a representation in their proposal stating that based on the change in the law, we are eligible small business under the 5-year standard. And contracting officers are within their discretion to recognize that. And so it's been a good thing, and I think when the subcommittee looks at the status quo, it needs to realize this is something that's been completed, it's done, it's in the books, and from my perspective as a mid-tier contractor lawyer, the community has been relying on that, and so to delay effectiveness or push that back at this point would be to take something away from the mid-tier small business contracting community that Congress has already provided. And so, good thing, and it should stay in effect. So what's been happening is basically SBA has been kicking up some sand and dust, and they've sort of put forth 2 arguments that have pretty easy solutions in the existing law. First, in the information notice that you alluded to, they say, well, you read the Runway Extension Act, and there was no effective date. So that means it's not effective until we issue our regulations. Well, the Supreme Court has an answer to that, and this is sort of basic principles of statutory construction, that when Congress passes a law, the omission, this is a quote from Johnson versus United States, a 2000 case, you should feel confident about what you did in December, because the omission of an express effective date simply indicates that absent clear congressional direction, it takes effect on its enactment date. And everybody knows this. And so the small business contracting community has relied on the absence of an effective date. There's no clear direction that Congress intended to delay it, quite the contrary. And so, that this ship has sailed, and SBA is just legally erroneous when they claim that it did not take immediate effect. And so the other thing they say is that the Section 3 of the Small Business Act, and that's where Congress has put these size regulations, the provision that sets forth the parameters for size standards, that's where the 3 and 5 year standards are and were and are, that somehow that doesn't apply to SBA. And I think everyone was surprised to hear this position. I mean, when you read the statute, that subsection says that when no department or agency may prescribe a regulation that conflicts with that. And there's a definition of federal agency in the statute that clearly includes SBA. And so the only carve-out from this is unless specifically authorized by statute. So Congress said, well, we might for another agency specifically authorized by statute. There's a subsection SBA points to. There's nothing in there that specifically says you are exempt from the size standard requirements that are in subsection A2C. So again, and so what the solutions are, clarifying amendments at most. Congress has done a good thing. It's not to push the deadline back, you don't want to take something away that's benefiting the community and push it back. Keep it in effect. You don't really need to clarify the effective date, but you could, December 17th, 2018. And then the other thing is to clarify that the subsection C, A2C, when you talk about federal agency, you could just put a little caret in there, say, including the administrator of SBA. And these are clarifying amendments that aren't changing the law, so they apply retroactively. You would just be clarifying what Congress has meant for decades, that SBA doesn't have this license to come up with its own size standards, and it maintains Congress's hook. You all want to set the policy in this area. You set it by applying it to every federal agency in that subsection, and you want to maintain that mechanism. So with that, again, thank you for the opportunity, and I look forward to answering the subcommittee's questions.
Thank you, Mr. Black. 10 seconds to spare. Ms. Connor, you're next. Thank you.
Good morning. Good morning, Chair Golden, Ranking Member Stauber, and distinguished members of the subcommittee. My name is Megan Connor, and I'm a partner at Polera Mazza, a law firm serving government contractors for over 30 years. We represent companies of all sizes in a variety of industries, and our firm supports the Runway Extension Act, and specifically changing how small businesses calculate their receipts from a 3-year basis to a 5-year basis. However, we believe in implementing this change, there are 3 issues that need to be addressed in order to avoid negative impacts on small businesses. First, small businesses deserve clarity as to the effective date of the change from 3 years to 5 years. Second, we strongly recommend a transition period during which firms may adjust to the new 5-year calculation. Third, the System for Award Management database must be updated to account for this change. I will address each of these issues in turn. First, there is widespread confusion in industry as to the effective date of the Runway Extension Act. Although it was signed into law on December 17, 2018, as Mr. Black stated, the SBA has taken the position that it's not presently effective. While we would normally advise clients that federal law supersedes SBA's regulations with still stating that 3 years is the basis of calculation and the information notice that SBA published has left contractors in a state of confusion. To illustrate the confusion this is creating, a client of ours submitted a proposal in October 2018 when the company was small under a 3-year calculation. As of January 1st, 2019, that company is no longer small under a 3-year calculation, but is small under a 5-year calculation. It recently had to update its representations and certifications for that same proposal. The company reiterated that it was small at the time of its initial proposal with price, which is the relevant date for size purposes, and also stated that it remains a small business pursuant to the Runway Extension Act. This company, and others like it, should be able to take advantage of the Runway Extension Act now. Accordingly, we recommend that Congress make clear its intent as to the effective date of the Runway Extension Act. It is my understanding that the committee is currently drafting legislation to address this. We appreciate the committee's efforts and urge the committee to ensure that firms that are benefited by the act may take advantage of it as of the date it became law. The second issue the committee should address in implementing the Runway Extension Act is a transition period, which would allow firms that are small under a 3-year calculation, but not small under a 5-year calculation, to adjust to this change. The reality is that the Runway Extension Act unintentionally may harm small businesses that are experiencing financial downturns. For example, if a contractor unexpectedly loses a valuable follow-on contract or graduates from the SBA's 8A program and is no longer eligible for 8A contracts. In both scenarios, the contractor often experiences a decrease in revenues after years of increases. Fluctuations also could be driven by the types of contracts a contractor has. For instance, if the company is a contract holder on a large contract vehicle and has won large dollar but short-term task orders in some of the recent fiscal years, but not every year, then it could experience these types of swings. Small businesses should be given the option to choose which calculation is most favorable for them, 3 years versus 5 years, for a short transition period. In this way, firms that are no longer considered small under a 5-year calculation will have time to prepare to compete as a so-called mid-sized firm in the unrestricted marketplace. Lastly, in implementing the Runway Extension Act, the System for Award Management Database, or SAM, should be updated to account for the change from 3 years to 5 years. When completing SAM registration, contractors must insert one amount representing their 3-year average receipts. To conform to the Runway Extension Act, SAM should be updated to request a 5-year average receipts calculation. In conclusion, the Runway Extension Act is a positive change for government contractors, but in implementing it, any potential negative impact should be mitigated through clarity for industry, a transition period for firms that are not benefited by the change, and an update to SAM. On behalf of Polaro Mazza and the government contractors we represent, I would like to commend the committee for continuing to consider how best to implement the Runway Extension Act. And I would like to thank the committee again for the opportunity to appear before you today. I look forward to your questions.
Thank you, Ms. Connor. Mr. Morales.
Thank you, Chairman Golden, Ranking Member Stauber, and members of the subcommittee for inviting me to testify today. On behalf of the National Electrical Contractors Association, NECA, and ProCal Lighting, I greatly appreciate the opportunity to submit a statement for the record. The subcommittee is to be commended for holding this hearing to better implement and enact the prudent bipartisan reforms signed into law in the previous Congress. My name is Brian Morales. I am the president and CEO of ProCal Lighting, which is located in Vista, California. As a second-generation Mexican-American and a participant of the NECA IBW program, I founded my company in 2014 with my father, Anthony Morales, a Purple Heart recipient and a Vietnam War veteran. Since that day, ProCal Lighting has provided energy-efficient design and installations to public schools, government buildings, and some of our nation's largest private industries. We at ProCal Lighting are proud members of the National Electrical Contractors Association, which serves as the voice of the 4,000 electrical contractors who make up the $171 billion electrical construction industry that brings power, light, and communication technology to buildings and communities across the U.S. Risk is inherent with any business venture, and a successful entrepreneur knows how to navigate this risk. In order to build a sustainable business and avoid undue risk, a business owner needs to be informed. For my company to continue to grow, our estimating team needs to consider the competition's approach and determine what level of risk exposure we have through formal requests for information and by receiving clear deliverables. The small business classification has allowed and continues to allow ProCal Lighting and many other NECA contractors the opportunity to understand this risk, learn from it, and be better suited to grow. On a personal note concerning ProCal Lighting, the small business classification has opened numerous opportunities for us to sit at the table of government procurement and competitively offer our services. Thanks to our small business classification, we as a company have seen benefits including access to various workshops, increased relationships with vendors, and industry resources like federal small business loans, and complimentary SBA training. These resources have aided our company in competitively securing government subcontracts, working on energy efficiency projects such as the Marine Corps Recruit Depot in San Diego, as well as the Customs and Border Patrol facilities in San Diego and Orange counties. We at NECA and ProCal Lighting were pleased to learn about the bipartisan legislation from last Congress, the H.R. 6330, which extended the small business calculation for average receipts from 3 to 5 years. This legislation is of particular benefit to companies like my own, who can say over a 5-year period, given the measure of our current anticipated revenues for this year and the following, ProCal Lighting would still hold its certification as a small business. If the same were to be evaluated over a 3-year period, we would lose our certification after year 2020. If we were to engage in discovering projects with the federal government, by the time the projects were funded and released for 8A certified contractors, we would be disqualified from participating and lose all that investment in developing and promoting this work. The new 5-year period, when combined with a finite phase-in period, benefits companies like mine by providing a measure of flexibility in determining our small business status. It also allows ProCal Lighting the ability to hold its small business certification for a longer period of time. This phase-in period would allow both contractors and the SBA time to properly account for the 5-year calculation while preparing businesses for the full implementation of the rule. Upon enactment of the previous Congress's legislation, ProCal Lighting can begin to acquire new clients on long-term contracts, having them become long-lasting revenue sources, and subsequently move our company into a safer financial position. With nearly 80% of NECA's contractor members classified as small businesses, legislation allowing our contractors to fully benefit from a small business classification is of utmost importance. As a small business contractor, I am extremely encouraged by this committee's efforts to revise and strengthen the Small Business Runway Extension Act. The further clarification and guidance of this legislation will be a key component for small business owners like myself and the 3,200 NECA small business contractors in mitigating the inherent risk of competing in our industry. Thank you again for the opportunity to testify. Both ProCal Lighting and NECA applaud the committee's unwavering efforts to re-examine the benefits of government programs for small businesses, and I look forward to answering any questions you may have.
Thank you, sir. Ms. Allen?
Good morning. Thank you, Chair Golden and Ranking Member Stauber. I want to thank you for the opportunity to testify on this very important topic. My name is Erin Allen. I'm the president of Contemporaries, and I'm testifying today on behalf of the Montgomery County Chamber of Commerce out of the state of Maryland. I'm here for two reasons. First, to thank you so much for the committee to work with us to pass the Small Business Runway Extension Act last year, and also to press for expedited implementation on this important law, which affects millions of businesses all over the country, just like mine. As government contracts become larger and small businesses grow, it's inevitable that they'll face very tough choices. The first being to grow beyond the small business programs to compete with large companies. The second is to stay small to avoid the difficulties of competing in the full and open market. Another option is to sell, and unfortunately the last and rather tragic option is to go out of business. As a result, there are only 1,700 mid-sized businesses doing federal work today. These firms compete not only with very large businesses, but also with small businesses who receive set-aside federal work. Before I go any further, I wanted to tell you a little bit about my company and our story, and why it's important to me. Excuse me, allergies are crazy. I'm a second-generation business owner. My parents started the company back in 1991. When I was tapped as president back then, we had just $4 million in sales. 15 years later, we're one of the largest providers of staffing services to the NIH, and as a result of that steady growth, we find ourselves at the top of our size standard, which is revenue-based. Our size standard is $7.5 million, which is microscopic in comparison to the very large businesses in our industry. My concern comes from having the time to accommodate future growth in a steady manner. The last 3 years have been really good for us, but the downside of that is that we risk losing that momentum should I continue that growth or be awarded a large contract. If the Runway Extension Act goes into effect, I'll have a few more critical years to build my infrastructure, develop talent, and comply with some costly new cybersecurity requirements. In the end, my goal is to grow the company, to create new jobs, and to contribute to the economy. Last year, a fellow chamber member, Steve Romley, recommended the changing the formula for small business eligibility to the lowest of 3 of 5 years to this committee. Ultimately, the legislation simply changed the current 3-year revenue average to 5-year for the purposes of determining size. The rationale behind this proposed change can be stated simply: competitiveness takes time to build. Revenue is not an indicator of present competitiveness. It's an indicator of future competitiveness. Having a good year or even a couple of good years does not mean that a company will continue to grow. Moving from the current 3-year look back to a 5-year look back would give firms more time to adjust to the full and open market. Not just big or small companies and mid-sized companies benefit from the Runway Extension Act. Any small business that intends to grow will eventually benefit from these changes. Further, having more well-qualified firms under the revenue standards will increase the chance that solicitations will be set aside and therefore will give all firms more opportunities to compete. Large businesses will also benefit because it increases the pool of well-qualified subcontractors. The Runway Extension Act, as passed by the last Congress, addresses these issues. We expected the change to be effective immediately. However, since its passage into law, the SBA has posed the argument that the size determinations changes would not take effect immediately, as the agency should first be able to utilize the rulemaking process and seek public comment. This decision by the SBA puts businesses in limbo. According to the Administrative Procedures Act, an agency can issue a final rule without publishing a proposed rule, and I quote, "Congress has already directed a specific regulatory outcome into law." We believe that there's no question as to the intent of Congress. There was a hearing, there was a markup, there was a clear congressional record, and specific statutory language leaving no discretion with respect to the regulatory outcome. While it seems unnecessary for Congress to reiterate its intent through this new legislation, we support any effort to insist on implementation. The damage caused by the delay is impacting small businesses all over the country, not just inside the Beltway. The longer implementation takes, the more uncertainty and confusion there is for all small business owners. On behalf of small business owners everywhere, I implore you to press for implementation of the Runway Extension Act. Thank you for the opportunity to testify today.
Thank you very much, Ms. Allen. I appreciate all the testimony that you've all just shared with us, and I'll begin now by recognizing myself for 5 minutes of questions. One of the recommendations that we've just heard to deal with the delay in the implementation of the Runway Extension Act is for Congress to pass legislation providing for an interim period in which the 3-year and 5-year formula would apply, leaving to contractors to decide which one to use. And this interim period would sunset on the date when the Runway Extension Act became effective or when the SBA issues their rules, whichever happens first. I believe, Ms. Connor, this is an approach that you have advocated for, and I see you're reaching for your button. But I think in the interest of having more opportunity for all of you to kind of talk about your different proposed solutions. I also want to lay out that an alternative to deal with the delay would be to pass a legislative amendment, something that Mr. Black talked about. So in the interest of furthering the discussion for everyone, I thought that I might ask Mr. Black, what do you think the advantages and or disadvantages of the proposed interim rule may be?
Sure. Well, I think it's not a bad thing to help what we call backsliding businesses that have emerged from small or maybe struggling to compete and are experiencing a reduction in revenues. At the same time, I think if Congress wants to help that part of the community, it needs to keep what it's done in place. It needs to maintain that continuity for the growing small businesses who, again, were relying on this law that went into effect on December 17th. And so there's a way to do that where you clarify that the 5-year amendment went into effect on December 17th, but then we're doing a new amendment to add back the 3-year standard for a period of time. And these are all sort of judgment calls. So, anecdotally in my practice, I think you are helping more small businesses who are the growers. I think, I don't have hard data. I have my experience in my day-to-day, and my experience is this law is benefiting. There are more businesses who are large under the 3 but small under the 5, and then there is a subset of the community. I just think it's smaller, and so this is one of those where Congress wants to think about: are we letting the tail wag the dog? If we do want to help the backsliders, let's do it in a way that makes sure we keep the help in place that we've given to the growing small businesses.
Thank you, Mr. Black. Ms. Connor, I thought I would ask you a similar question, if you could, put a different cap on maybe and think a little bit about the proposed solution that Mr. Black has. What are some of the flaws with that approach and potential benefits from your perspective?
Well, the benefit is that obviously SBA is not implementing this change, and so the major benefit would then they would have no choice. I think it's unfortunate that it's come to that, because that subsection of the Act, when you read it, it's clear that it applies to SBA because it speaks to a federal agency issuing size standards. And to my knowledge, there is no other federal agency that issues size standards besides the SBA. And then it speaks to the SBA's rulemaking process for doing so. So it's unfortunate that the committee and that Congress is put into that position by another branch of government that they're refusing to implement this very simple change. But with that said, I think my one concern would be that the SBA size standard process is so slow, and it does not, in my opinion, capture small businesses fairly. The current size standards have been in place since 2012 and are based on data from 2010, 2011. And if you look at businesses now, it's 9 years later. They have different expectations, different operating costs. It's just not a fair representation. So I would hate for anything that would slow down the size standard process any further.
Thank you, Ms. Connor. You know, in light of the delay that's taking place, I just thought I would ask if you have any questions as well in the last few seconds that I'm leaving you here. You know, what confidence might the committee have that, you know, taking you know, the approach that you proposed wouldn't result in further delays and kind of slow rolling of the process from SBA?
The transition period creates all winners. That's what's so great about it. If you are small under 3 years, you're still small until some date in the future. If you're small under 5 years, you're small, and you can continue to pursue procurements for the next, whatever the transition period is, and then thereafter when the 5-year rule is permanent and effective. So the transition period, in my mind, just creates a pool of winners instead of winners and losers. And I don't know what SBA's intent is and why they've issued that information notice and why they're slow to act. But if I had to speculate, I suspect that they might be concerned about the losers under the Runway Extension Act, i.e. the businesses that are small under 3 years, but not small under 5. And the transition period addresses what I think could be their concern. So I understand the delay, but once it's in the act, and then if the Congress says that this is to be an interim final rule and comments would be allowed, then it's done.
Thank you very much. My time has expired. I now recognize the ranking member of the subcommittee, Mr. Stauber, for 5 minutes.
Thank you, Mr. Chair. A couple of questions or comments before I ask the question. The passion is, I hear loudly and clearly, to immediately implement it. Mr. Black, you made a couple of comments that really resonate. Sometimes the intention or what we desire in Congress doesn't make it to the implementation the way it should. And so this is one of the, this hearing is to change that. I, as one member, hear it loudly and clearly. So the goal is to make this happen, to work with the SBA to make sure that it's understood, that it helps a small business. Each and every one of you talked about how it will help us. Nika's involved. That's very important for us to hear that. I have been a small business owner for 28 years. I get it. And so a couple of questions I will ask Ms. Allen. You know, you mentioned in your testimony the administrator committed the agency to start working on the rulemaking immediately. Are there any consequences, both long-term or otherwise, for firms that might lose their small business status during these months, but gain it back once the SBA issues its final ruling?
So, you know, uncertainty is never good, right, in small businesses. And so I would just urge, honestly, whatever decision is going to be made, just make it and get it done and over with. I mean, honestly, that to me is the biggest, if I can say nothing else, it's that. But insofar as, you know, small businesses, the wishy-washy is a problem. For me as a small business, I know that it was the greatest Christmas gift I could have ever gotten when that because this has been weighing heavily on my head for a long time of what's going to happen to us, and we've been planning and making, you know, infrastructure changes and hiring new employees. And I know that a lot of my colleagues within the business community is doing the same. So it's super critical for us. And I think that the 5-year look back is going to be huge for us. I don't know if that answers your question. Is that yes, no?
Not allowing our small businesses to be in limbo is critically important.
Yeah.
That's where you're at right now.
Absolutely.
And to Mr. Black, your point of looking and researching other case law, it makes sense that the intention was to have it enacted, immediately. One of the questions that I had was, I know that in the small business community, there's ups and downs. In any look back, give me both a positive and a negative look back from either the implementation or non-implementation of this immediately. So what's the positive and what's the negative? You alluded to, but I want to hear it again.
Okay. Well, the positive, of course, is that businesses, the small business size standard is relevant on the date you submit a proposal for contracts. That's the date. If you're small on that date, you're small and you win the contract, you're small for the rest of the life of the contract. And so that date, the benefit, if you're small, if you're small under the 5-year but not the 3-year, that means in 2019 you have opportunities that you wouldn't otherwise have. And if there's ambiguity or the OHA's SBA Office of Hearings Appeals reaches a different opinion and a business loses a size protest, these opportunities aren't coming back. 2019, they'll lose the revenue. Contracts for programs are typically awarded every 5 years. It won't be coming around. They won't be small. And so it's critical that the positive and the negative are the same thing. When it's clear you're small, you have opportunities now. When it's unclear or you're not small, you lose those opportunities and you won't get them back.
Yeah, and I think that I just go back to the fluctuation in the mindset of our small businesses. Our goal is to make sure that you know where you sit and the rules are present today, and the standards are there for the small businesses. And I think that all in all, I really appreciate your comments and your success in small business. It's not easy. I have said this many times in this committee that small businesses are the engine of our economy, and we will. I know that the chair and I feel the same way. Coming from rural America, you are Main Street businesses, and I really appreciate your testimony today. Mr. Chair, I yield back.
Thank you. The gentleman yields back. We'll now recognize the gentleman from Ohio, Representative Balderson, ranking member of the Subcommittee on Innovation and Workforce Development, for 5 minutes.
Thank you, Chairman. Good morning, everyone. This question is for Mrs. Allen. Good morning, Mrs. Allen. In your testimony, you talked about the mid-sized crisis of the contractual growth. Can you share how these 2 extra years from the Runway Act can help a small business successfully integrate into the open market without kicking the can down the road?
Yeah, though I'd like to kick it further, but yes. No, it really helps because it gives us an opportunity to, as I said, to grow our infrastructure, to hire new employees. If we want, we could, acquire other small businesses to make us larger and more competitive, or to joint venture with them, to develop some of those relationships that we wouldn't have otherwise needed. As a small business, you can kind of do your thing. You don't need the big, behemoths. You don't need to have as many joint ventures to operate. But when you are competing against the Lockheed Martins and the SAICs and Leidos of the world, you need to have a whole army of folks with you. So it would give us time to put that consortium of people together.
Okay, and thank you. I have one follow-up question for you. In your opinion, how has the confusion over the 3 or 5 year affected contracting firms' willingness to hire new employees and expand their workforce?
Sure. I mean, any uncertainty as a business owner, if I'm in a position of, okay, well, so next month I'm going to be small or am I going to be large? I'm not going to take that risk and hire new employees. It just doesn't make sense, the bottom line, and then have to turn around and get rid of them because, oh my gosh, now I can't afford, I'm not going to be able to compete for those businesses because I'm no longer small. And so that really puts a huge pressure on businesses. And so, yeah, whether you're large or small, that uncertainty is not good. Yeah.
Thank you very much for your answers, and I yield back my remaining time.
Gentleman yields back his time. Will now recognize for 5 minutes Representative Jim Hagedorn.
Well, thank you, Mr. Chair and Ranking Republican Member Stauber, fellow Minnesotan. It's a pleasure to be here. Thanks to the witnesses and the staff and everyone. I'd first like to recognize a friend of ours who's in the audience, former Congressman Tom Davis. Tom, appreciate your public service. It's nice to see you today. Hope things are going well. Ms. Allen, so the concept here, I guess, is that small business begins to grow. You're involved in these contracts and other things, and we should maybe set some different limitations or, expand it so we don't have to, just stop the whole process. I get that. We want businesses to grow. We don't want to disrupt the apple cart and all that. But And by the way, I thought the concept of maybe the 3 lowest years, that might make more sense if you're looking over 5. But if this is a good concept, and we don't want to have businesses run out of business or limited because of bad government, why don't we apply it to everything else that the government mandates? I mean, you look at labor laws, you look at health care with Obamacare. I've spoken to a lot of business owners in southern Minnesota who were concerned that their business was getting too good. They're starting to grow. They're starting to hire more people. They were thinking about going out and buying other businesses and, doing all sorts of things. But because of the limits that are imposed on them on Obamacare and other statutes by the federal government, they had to think twice about that. Oftentimes, they deferred and decided not to. What do you think about that concept? Should we be maybe looking at other statutes and seeing how it impedes small business progress?
Absolutely. Amen. Let's do it. I think that anything that impedes the growth of particularly small businesses is, welcome. Are there other statutes and limitations? I'm sure there are, and I think that that would be valuable. I think all of us would applaud that. What are the right ones to change and monkey with? I will leave that in your very capable hands.
Well, I just say if this is a good idea, this is a good bill, seems to be bipartisan, maybe we should look to apply it to all other aspects of government to make sure our small businesses can prosper, thrive, and grow and expand and compete ultimately with bigger businesses. With that, I yield back. Thank you.
Gentleman from Minnesota is yielded back. Now move into a second round of questioning for those who want to, and I think I will start myself for an additional 5 minutes. I wanted to ask Mr. Morales, I think if I understood correctly during your testimony, you were saying that, under the 3-year rule in 2019, you're small. By 2020, you would have grown out of that. So I wanted to ask, or just give you another opportunity to tell us about how the delay in implementing this law has left you in limbo with a little bit of uncertainty. How's that going to impact your planning for what you do, compete for, or take on in 2019, looking beyond it to 2020?
I think some background information about our company would be beneficial in this case. We started in 2014, so we're a relatively new company. Because of our tremendous growth, we've been able to go through a lot of processes that the SBA programs has helped us go through and understand. This current year is going to be our largest revenue year to date. And when I was mentioning that if we continued this same type of revenue for the following year, under the 3-year rule, we would lose our small business status. Now, that's not to mean the previous years in which I've started the business were even close to breaching that. We just had really good, successful years this year. So again, the idea is we're a small 5-year-old company who just had a tremendous year and still are learning from the processes of contracting with the government that we need to understand more formally. A big part in our, particular to our company, is we began our 8A application mid-year last year. It's been quite a bit of time that we've divested into this program, a lot of office time, a lot of monies, trying to get that 8A certification. It's currently in the part of being processed, and if we were to continue revenues, we would get the 8A in 2019 just to lose it after 2020, and that's under the 3-year rule. So if we were to have the 5-year rule implemented immediately, that would help us plan. It would help us to look at what kind of solicitations we need to do, what type of contract engagements we need to have and participate in. We also want to start in right away with creating mentorship programs under the 8A. And if we began that process only to lose that certification because we're no longer a small business, then it would be a lot of wasted time and effort and monies also.
Sorry about that. You could hear me? Good. All right. I thought I might ask if you would just follow up in your experience. Probably you know of businesses, maybe even your own, struggling with the same kind of uncertainty and challenges that Mr. Morales was talking about. But I was wondering if there are other common repercussions that you might speak to as a result of the delay of the act.
See. The delay really puts us in a precarious position because there are contracts that we would love to go after, but if we are going to be considered large, we can't. And, you know, teaming arrangements that we put together, we do a lot of mentoring with, not formal mentoring relationships, but mentoring of other small businesses that we help and they subcontract under us. And, you know, if that change happens, not only does it affect me, but it affects all those other small businesses that no longer can team with me. And some might say, well, we could reverse it. They're not in a position to be able to prime a contract. They're not large enough. They're not a large enough small to be able to prime those small businesses. So it really puts all of us in this really wonky period. So, yeah.
Thank you all very much. I want to thank all of the witnesses for taking the time out of their schedules to be here with us today. I understand there are no additional questions. I will say that ensuring that small businesses can thrive is the #1 priority of this committee. As we've heard today, the SBA's delay in the implementation of the Runway Extension Act is creating widespread confusion and uncertainty. It's clear from our hearing that there are several alternatives that can be implemented to address this issue. And I look forward to working with my colleagues on both sides of the aisle to ensure that small businesses have access to federal contracting opportunities that Congress intends so these companies can continue to grow and add jobs to the economy. You know, I think that the ranking member and I agree that we're looking for the fastest solution to provide the quickest clarity for everyone that is out there that will be impacted either by further delay or hopefully a quick resolution. With that, I would ask unanimous consent that members have 5 legislative days to submit statements and supporting materials for the record. Without objections, so ordered. If there's no further business to come before the committee, we're adjourned. Thank you very much.